So we've already looked back on 2024 CRPA litigation. Perhaps it's time to look at some litigation that's been going on around the country for the year, because after all, what goes around comes around, and ultimately it will affect us here in California. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, just like we did the CRPA litigation, I thought it would be a good idea to take a look back at 2024 litigation outside the state of California. To do that, we have brought back the CRPA president, Chuck Michel. Chuck, thanks for being with us today.
Always a pleasure, fellas. Thanks for having me.
Absolutely. And guys, go ahead and check out the CRPA store. You can find this at crpa.org. If you want to look good like Chuck and sport the 150th anniversary merch that we got in there, go ahead and head over to there. We have stuff on sale. It's going quickly, so if you want to commemorate the 150th year of CRPA fighting for Second Amendment rights, make sure to get over there quick. And actually, Jacob, maybe we can drop a link to the store down there in the description for the video. But guys, before we get into it today, please be sure to like, share, and subscribe to these videos. It really helps get this information out to as many people as possible. We want our Second Amendment advocates to stay armed with the truth. The best way to do that is to capture the knowledge from these videos that we're trying to put out. So Chuck, kind of similar to what we did in the last time that we had you on going through the CRPA litigation, I thought it would be a good idea because, as we discussed in that video, there is a lot of litigation that CRPA influences around the nation with the conclusions and the injunctions that we get on California laws, and vice versa. We can also have a lot of litigation external to the state of California or the Ninth Circuit affecting litigation here that we have. So the first one that I thought we could go through was the FFLs versus the FFLs of Illinois versus Pritzker lawsuit. I think we filed an amicus brief on this one, and it was a challenge to the magazine capacity and the assault weapons bans over there in Illinois. Can you give us a brief walkthrough on that one and how it might affect us here in California?
Sure. Let me take a second though and explain something to folks about what this is a national game, fighting for the Second Amendment. And the forces that are against the Second Amendment, backed mostly by Michael Bloomberg and his Everytown Law group, are sort of spoon-feeding model laws to anti-gun politicians in the battleground states, the purple or blue states, to try and get them to pass as many laws as they can and kind of test the limits of the Second Amendment and force the pro-Second Amendment groups to spend a lot of money litigating all these things. It's also important to keep in mind, when it comes to court decisions, there are a couple types of authority. There's persuasive authority and there's mandatory authority. With persuasive authority, for example, if the Second Circuit issues a ruling that some gun control law is constitutional, but the Fifth Circuit issues a law that says it's not constitutional, whatever the Second or Fifth Amendment said, Fifth Circuit said, could be cited in the Ninth Circuit. The Ninth Circuit is not bound by Second or Fifth Amendment authority, but it could be persuasive. So depending on how well reasoned it is, and whether or not the judges in the Ninth Circuit agree with the reasoning, they may be persuaded by the opinion from another circuit court. Now, if you have a Ninth Circuit opinion that comes down out of California and they want to do something different in Montana, Montana is in the Ninth Circuit, so whatever the Ninth Circuit said about a California law would apply and be mandatory authority when evaluating a Montana law. So we have to try and get as much persuasive and mandatory authority as we can. Ultimately, there's a lot of fights that are going to make their way to the Supreme Court. That one of those, which has been there and will probably be there again, is the FFLs of Illinois versus Pritzker. This was actually 4 different cases with a lot of the biggest players, biggest pro-gun players, pro-Second Amendment players involved. Second Amendment Foundation, the FFL Illinois, the GOA, Gun Owners of America, Gun Owners Foundation, Gun Owners of California, and others have all been litigating in cases in Illinois. We filed in the Southern District which is a rather rural area. We got a great judge, Judge McGlynn, who is right up there with Judge Benitez, I think, in terms of getting it. And we challenged the Illinois ban on semi-autos and magazines and parts. I mean, it's probably the broadest uh, firearm ban in the country in its scope. We litigated this in front of Judge McGlynn initially. We won a preliminary injunction. The state immediately appealed. This is a Second Amendment challenge. They immediately appealed, and they got this up to the Seventh Circuit. The Seventh Circuit, we had a three-judge panel, which included Judge Easterbrook, who is notoriously anti-Second Amendment. And not surprisingly, we lost in the Seventh Circuit. But interestingly, the Seventh Circuit said, we don't have enough facts here to say for sure that some of these guns can be banned. And they made this artificial distinction between military use and civilian use, which is interesting because ultimately, if you say that guns that are used for the military can't be used by civilians, you're basically saying that the best guns, I'm not talking about necessarily fully automatic, but the finest designs in semi-automatics at least, can't be used by civilians. And that's what the Seventh Circuit said. They basically said the AR-15 is too much like the fully automatic M16. It's a military application, so you can ban AR-15s. But they said, we haven't really got expert testimony on that. So we're going to remand it and let Judge McGlynn again now try the case, not the preliminary injunction. It actually goes all the way through till trial. Remember, you start the case, you file your complaint, you move for a preliminary injunction if appropriate. And then when you win or lose, there goes discovery and expert testimony. And then you go to a trial, and at trial you get a judgment. So the Seventh Circuit sends the court back to Judge McGlynn. He had a trial, a week-long trial, where all the main players, the lawyers were there, and we had all these experts that we've used in California, interestingly enough, in the past, to talk about what the AR-15 does and does not do, and how it is not the same as an M16. And interestingly enough, we won again in front of Judge McGlynn, and he made a lot of factual findings this time around about what the AR-15 is and is not in terms of military applications. And, we don't think the military application really has anything to do with it. Our position is, if it's in common use, Heller says it's protected because it's not dangerous and unusual. But the Seventh Circuit made us go through these hoops, these factual development hoops, to show that the AR-15 was a very different gun from the M16, and all these other semi-autos all had legitimate civilian uses, not just for self-defense, but for sport shooting, hunting, marksmanship, whatever. So after that 1 week trial, Judge McGlynn issued a long decision, that very thoroughly documented decision, saying the experts have testified, and I find that AR-15s are not the same as M16s. They're not just military applications. They have legitimate civilian uses for self-defense, and he struck down the law. The state immediately appealed that to the Seventh Circuit. The Seventh Circuit stayed his judgment so that it could not block the enforcement of the law while the Seventh Circuit considered it again. And this time we have one different judge on the three-judge panel, but Judge Easterbrook is still there, so we'll see what happens. But that case is now in the Seventh Circuit. Interestingly enough, that case did take a side trip to the Supreme Court. And one of the things we're learning about the Supreme Court's inclination to take a Second Amendment case is they don't really like to take a case right after the preliminary injunction or an injunction phase. They want the case to have been litigated all the way through. They want the facts to have been developed. They want to hear cases that have gone to judgment. That is now what Illinois has done. After we lost the preliminary injunction appeal in the Seventh Circuit, we asked the Supreme Court to weigh in. They declined. But while they're declining these cases that are still in the preliminary phases, they are saying, bring this back. They're showing that there's an interest in resolving some of these issues, just not at the preliminary injunction phase. They want that judgment. So now in the Seventh Circuit, there is a judgment and they will have to decide whether or not Judge McGlynn was right in all the facts that he found and all the factual findings that he made, and what all the experts on on the plaintiff side, our side said, and then decide whether or not this Illinois semi-auto ban law is constitutional or not. I expect if we lose, we will absolutely take it to the Supreme Court again. And I think the Supreme Court is ready to take a case. Hopefully we'll talk about the Snopes case in a minute, but hopefully they'll take that Maryland semi-auto ban case, which is in front of them right now.
Well, yes, and sometimes it's a little bit confusing. I don't know whether or not I should be comforted or really sad just by understanding that there are places in the United States that suffer with the court systems like we do here in California with the Ninth Circuit. But yeah, I guess before talking about how this is going to potentially affect litigation in California, let's throw the Snope v. Brown case in there. Can you give us a brief history on that one? It's a challenge to Maryland's assault weapons bans as well.
Yeah, this was another one that went up on preliminary injunction, went back down, and went all the way through trial to judgment. So there is a judgment. That's a good thing because that's what the Supreme Court is looking for when they're considering a case to take. Remember, the Supreme Court doesn't have to take a case. It takes 4 judges to vote to take a case, 5 judges out of 9 to win a case in the Supreme Court. So again, as I said, they've telegraphed that what they're looking for is cases that have been taken to judgment, final judgment. All the facts have been developed, all the testimony has been given by the experts, and that's what happened in Maryland. So that case is ripe for the Supreme Court to take it. The Supreme Court had it scheduled for a conference, in other words, a meeting of the judges to decide whether to take it or not, and then postponed that meeting. I think it might be next week. I'm forgetting right now, but it's coming up soon. And they're going to decide whether they want to take that case and decide whether Maryland's semi-auto ban is constitutional or not.
And when we're talking about our expectation of the Supreme Court, I guess first of all, you said that Supreme Court doesn't have to take a case. I guess the inverse is also true. They can take as many cases as they want. And what we're really looking for over here is for them to continue and define the scope with which our court system should judge Second Amendment challenges. When you're looking at FFLs of Illinois versus Pritzker or Snope versus Brown, you already kind of said FFLs of Illinois has a little bit of a broader scope, also including the magazine bans. If not both, if you had to choose one, which one do you hope that the Supreme Court takes up? One a little bit more narrow in scope, specifically looking at assault weapons laws, or the broader one?
I'm not sure that the scope of the law really matters. It's whether or not a gun that's in common use for lawful purposes can be banned. That's going to apply across the board. The magazine issue is an interesting sideshow. They're trying to argue that magazines are not arms, so there's no right to keep and ban magazines bear magazines because they're not arms. Of course, they're an arm part. If you can ban the magazine, why can't you ban the barrel? But that's a side issue that's going to have to be resolved. What exactly are arms that are protected by the Second Amendment? But I just want the court to get to it sooner rather than later. The Seventh Circuit's months away from ruling on our case, the case in Illinois. So I want them to take the Maryland case right away and resolve this court session, because it will be mandatory authority. Supreme Court rulings are mandatory across the country. It will be mandatory authority that applies to semi-automatic bans in every state. So California, Illinois, Oregon, wherever else a semi-auto ban exists. If the Supreme Court changes the test and says there's no fact finding about whether or not it's primarily military use or civilian use and all this other baloney, the question is, under Heller, whether the firearm is commonly possessed for lawful purposes. And AR-15s are one of the most, if not the most common firearm possessed by civilians for multiple purposes, including self-defense, all of them lawful, even though they're misused by criminals because they're such a large part of the universe of guns. It's not surprising that they turn up in some crime scenes, although not as many as handguns for sure. But anyway, so I want the Supreme Court to take this case and get this issue resolved so that it applies across the country, knocks out California, knocks out Illinois, knocks out wherever else there's a semi-auto ban.
Yeah, fair enough. The sooner they get it and rule on it, the sooner we can potentially lift some bans that we have here. Let's move to potentially more friendly court, let's talk about U.S. versus Ayala, another case that looks like it may be eventually headed to the Supreme Court, and an issue that we are sincerely struggling with here in the Ninth Circuit, having to do with sensitive places out of Florida. Can you give us a brief description of this one?
Well, this was a postal worker who was charged with having a firearm on at the post office. And so the question is a post office really a sensitive place? Is that a place where you can ban firearms because it's sensitive? Remember in Heller and McDonald, in Heller and Bruin, they talked about the government can ban firearm possession in certain sensitive places like polling places, some government buildings, a courthouse. But the anti-gun lobby has taken that and tried to drive a truck through it with all the places that they are now deeming to be sensitive. There's nothing particularly sensitive about a post office. People don't go in there and get, emotionally aroused like you might at a government building or a courthouse where there might be a divorce proceeding going on or somebody being charged criminally and the victims are there. I mean, those types of places might have a legitimate reason to want to completely ban firearm possession. But there's no such thing at a post office or a bar or all these other places that they're trying, parking lots where they're trying to say that you can't, that's a sensitive place, so you can't possess your gun. So this tests the limit of the sensitive places doctrine. CRPA and the Second Amendment Law Center both submitted an amicus brief in this case. Each submitted an amicus brief. And that's what we're doing across the country. CRPA keeps an eye on these cases across the country that might have persuasive authority in the Ninth Circuit or in the California state courts. So we want those wins everywhere across the country so that we can use them here in California.
Is this not maybe looked at as an incredible opportunity? I mean, here in California, we're kind of scratching our heads. California and New York, most notably, really trying to circumvent the Bruin decision, which they actually took some time and talked specifically about sensitive places in the Bruin decision. Here you've got a friendly court where the assumption is even if it goes in favor of the Second Amendment advocates, it's going to get appealed. What's your opinion on whether or not the Supreme Court is kind of frothing at the mouth to take this one to dive even deeper into sensitive places?
I don't know that this is as high profile to the Supreme Court as Antonok, the New York sensitive places case, which is much further along. And this is a criminal case. A lot of times they're leery about taking criminal cases. The Rahimi was a criminal case. They don't like to let people. It makes it more difficult if there's a criminal aspect to it because you're arguing on behalf of a criminal defendant. But I think the Supreme Court is much more likely to take the New York State sensitive places case because it's been up there once and they said we're interested, but take it to trial first and then bring it back.
Well, hopefully some more clarification will really help us clear up with what we've got in the Ninth Circuit with the May v. Bonta suit. That's really the connection that we're trying to draw with this one. Let's zoom out a little bit. Let's not talk about Americans suing Americans. Let's talk about Mexicans suing Americans really quick. Kind of drawing a line to something we have seen in California with laws on our books. I think it was Senate Bill 1327 from a couple of years ago. Gavin Newsom and Rob Bonta coming out and being very proud of the fact that Californians can have an avenue to sue firearms manufacturers. Here in the Smith & Wesson versus United Mexican States lawsuit, you essentially have the country of Mexico suing firearms manufacturers here. Can you go ahead and give us a brief rundown on this one and how it might affect us here?
Well, yeah, this is a lot of this has to do with whether or not the Protection of Lawful Commerce in Arms Act, which was enacted over a decade ago, to protect manufacturers from frivolous lawsuits that were trying to hold a firearm manufacturer civilly liable, for the criminal misuse of their products by a bad guy. This is like holding someone responsible for something that they was completely, beyond their control. They had nothing to do with it. Well, Mexico is blaming the gun manufacturers for cartel violence, drug dealer violence in Mexico. because some of these firearms are smuggled into Mexico illegally and then misused down there. Now, never mind that Mexico, there's an awful lot of things the Mexican government could be doing that they're not doing because there's an awful lot of I would say, flat out corruption in the Mexican government that stops them from doing certain things to the drug trade or for illegal immigration for that matter, or for smuggling. But so Mexico wants to hold the American firearms industry liable. And this is part of a bigger gambit by the gun ban lobby again. Years ago, they tried suing they recruited a number of municipalities to sue the gun industry, claiming that they were responsible for criminal misuse of their products. Now, this is the firearms manufacturing industry makes in a year what the tobacco industry makes in a day. They don't have the pockets that are as deep as people might think. So clearly, when these municipalities banded together, and now as we get more of these products liability or civil liability lawsuits, it's designed to cost the firearms industry money and hopefully put some out of business, some manufacturers out of business. And that's part of, I think, what the motivation for the Mexico suit is, other than political grandstanding by the Mexican government to blame America for the problems that it's got.
Well, if I remember, the attorney representing the United Mexican States is an American who went down there to I think it was he's from one of the anti-gun groups that operates out of Florida, and if I remember correctly, also this lawsuit did get filed in a very not friendly to the Second Amendment court. If it does get to the Supreme Court, I'm just wondering, in your opinion, how does a decision on something like this scale? Does something when you're talking about a government suing firearms manufacturers scale down to say a challenge to Senate Bill 1327 here in California?
Yes and no. There are international law issues in this one. As I said, there's the Protection of Lawful Commerce and Arms Act, and whether or not that's a defense to these kind of claims to try and impose liability on a manufacturer for the criminal misuse of its products. There are a number of other issues in this case which may or may not translate into state laws like those in California. But it's still, I think, the Supreme Court has taken it. So it shows that they're very interested in resolving some of these issues. And now, whether or not that really gets into the Second Amendment and the Second Amendment analysis remains to be seen, because it could be decided on some other grounds. But nonetheless, it's a very interesting case.
Well, let's divert then to a perhaps a more friendly court in Texas. Can you tell us about the Vanderstock v. Garland case? This one coming out of Texas, looks like we've already gotten a couple of good decisions on the regulating of firearms kits and parts.
Yeah, so this is again probably not really a Second Amendment focused case. It's more of an administrative law. The ATF, depending on the political leadership there, reinterprets its own rules to make things illegal that it's said for years are legal. In this case, the issue is so-called ghost guns, it's homemade firearms that the ATF decided to condemn and call an illegal product by regulatory fiat, not by some law passed by Congress. And so this is a sort of an administrative law question, whether or not the ATF can do that and whether or not the ATF is interpreting the statute correctly to give it the authority to call ghost guns an illegal product. And this also ties into the Chevron doctrine, where and we're going to talk about that in a minute, where the courts were compelled to defer to an administrative agency's interpretation of a law in deciding how much power that law gave them, to regulate various things or decide that certain things were illegal or legal. And in the past, the courts have had to give deference to the administrative agency's determination. Well, an administrative agency has never argued to give itself less power. There's never been,
Right.
That's not the way they work. Government entities always argue in favor of giving themselves more power to do whatever they want to do. Interestingly enough, the lawyers representing administrative agencies, executive agencies, don't represent the people as they should. They represent the agency and the people that run the agency. And those people are political, and they want more political power, and they want more regulatory authority. So they argue that anything they want to be illegal, they have the authority to make illegal, even if they're really just driven by a policy rather than a law. So that's what this case attests. It comes on the heels of Cargill, which was the case that dealt with bump stocks. So I expect we're going to get a similar result in this case, saying that the ATF can't just turn something into a crime that hasn't been. But we'll also see what happens with the Trump administration. The Trump administration may decide to drop this case because this is the United States DOJ appealing to the Supreme Court to say that the ATF does have the authority to.
Yeah, I guess that's something that I didn't even think to consider is with the change in administration, there are some of these cases that could just be dropped because of that change in administration. You mentioned it a couple of minutes ago in reference to the Vanderstock case. Let's talk about the Loper Bright Enterprises versus Raimondo case. This wasn't a Second Amendment case at all, but it does directly affect a lot of the ATF regulation. Well, really all the agency regulations, right? Can you go? Right. So, and I think that's an important distinction that I want you to discuss if you can. There is a difference between the Federal Department of Justice and the State Department of Justice, correct? So, go ahead and can you just give us a rundown, not of the Loper Bright Enterprise case, but in the thing that really matters that came from it, which was the Chevron doctrine basically getting thrown out and some of the impact that we've already seen in the courts.
Right. It was a different regulatory agency in that case, but the court nonetheless said that these agencies are not objective. They're biased. And in being biased, they interpret regulations and statutes, laws, in the way that's most favorable to them. So there's no particular reason why courts should say, okay, well, you're the agency who is in charge of regulating this thing, so we're going to give you some type of deference. We're going to say, we're going to presume that you're correct in the way you're interpreting things. That's what the courts are for, is to look at both sides and decide for themselves what a statute does or does not authorize an administrative agency to regulate. And so it was a very significant case in that respect, because it doesn't just apply to one administrative agency. It applies to all federal administrative agencies, and that obviously includes the ATF. So that should be very helpful in protecting the right to keep and bear arms, because the ATF, if the ATF or the DOJ is a politicized entity, they push policy preferences that may be in line with the Biden administration, but interestingly enough, may not be aligned with the Trump administration's policies. So it'll be interesting to see how that plays out.
Well, and here, I guess here's the thing. This isn't a reason to not be excited about this, but you read the headline, the Chevron doctrine is thrown out. We're not giving deference to these agencies anymore. However, it's in regards to federal agencies, not state agencies. Is there any line that can be drawn? I mean, are state agencies still looked at a little bit different now that we know that on the federal level they're not given that deference?
There was not a mandatory. The Chevron doctrine came about because of the case where Chevron was a party to the Chevron oil company was a party to the case. There's no similar Chevron doctrine mandate at the state law level. So the state agencies don't get quite the same amount of deference when they say a law does or does not allow them to do something. So we still have to fight that in California courts and other state courts.
So while we're on some of these bigger decisions that we saw from the Supreme Court this year, let's go ahead and talk about the Rahimi decision. Can you go ahead and just give us a brief description of that and how it might affect us here in California?
Well, this was a prohibited persons case. Remember, there are prohibited persons, prohibited places, prohibited hardware, prohibited firearms. So those are the three broad categories of gun control laws. This was a case about whether or not Mr. Rahimi, who was a convicted felon and had also had a restraining order issued against him, could be banned from possessing firearms. The court said that the government could ban him from possessing firearms, but they sidestepped a lot of issues that might have hurt us had they been forced to address them directly. They did what's called an as-applied challenge. In other words, they only addressed whether or not this particular individual with his particular individual circumstances could be prohibited from owning firearms. And in his case, he had a due process hearing. He was given an opportunity to be heard and say why he should not be prohibited. And he was found to be dangerous. And so the court said, because he was found to be dangerous, you could prohibit him from possessing firearms. Now the gun ban lobby is trying to make a lot out of that because the court used a couple different historical statutes and kind of put them together to say that there is historical analog statutes that would show that the founders would tolerate this kind of a modern day statute. So the biggest thing that really came out of Rahimi is another argument about what kind of historical analogs you really have to have in order to justify a modern day law. Remember, the Bruin test is it covered by the language of the Second Amendment? In other words, is it an arm? And are you keeping or bearing it? And then if it is, then the burden shifts to the government to show that there is some historical tradition, basically, of the type of law that's being challenged. And so that's what they did in Rahimi. They said, yes, this person was protected by, all people are protected by the Second Amendment, and then unless they can be prohibited, and in this particular case, this individual, because of, again, what happened with him and his individual circumstances, could be banned from possessing firearms.
Right, and that was the one where you have the mainstream media headlines talking about how Rahimi lost in the decision or the opinion, but at the end of the day, there was a narrowing of scope that can be beneficial to CRPA and really all Second Amendment litigation going forward. So hopefully we get some benefits from that with litigation moving forward. I want to finish this up with you. I know that the premise here is litigation outside the Ninth Circuit, but there were a couple that did happen in the Ninth Circuit that weren't CRPA lawsuits. I wanted to talk to you about USA versus Duarte. This one was kind of a mixed bag as far as people that I've talked to and a lot of the chatter online. This is nonviolent felons who can now legally own firearms per the opinion of the Ninth Circuit. Do you see this one continuing to move through the court system?
Well, this was a nonviolent, this is another prohibited person case. In this case, this person was a nonviolent felon who was prohibited from owning firearms. He challenged the law. The three-judge panel said there's no historical analog to banning firearm possession by nonviolent felons. And so that case, then the government asked to take it en banc to the 11-judge panel, which the en banc court took it because the Ninth Circuit, enough of the judges on the Ninth Circuit don't like the Second Amendment. They want to take it up. And so the fact that three judges on the three-judge panel had ruled that this law was unconstitutional, that got their attention. So that case has now been argued en banc in front of the 11 judges. And there was a lot of interesting back and forth between the judges on the en banc panel. Remember, this is kind of a random draw. It's supposed to be in theory anyway. But the Ninth Circuit composition has changed because of the last Trump administration. And it used to be basically 1/3 progressive judges, 2/3 progressive judges, 1/3 more conservative justices. Now it's about half and half. So you had a mixed panel there, and it's really hard to predict. It's kind of a coin toss how this en banc panel is going to rule about whether or not nonviolent felons as a group can be prohibited from owning guns.
Well, something definitely to follow along there. And then maybe we can finish up here. This one's a little bit more recent and out of Oregon. Arnold versus Kotek, challenging Oregon's Measure 114, banning magazines that can hold more than 10 rounds, found unconstitutional in an Oregon court. We talk about circuit splits as far as, cases maybe being wanted to be taken up by the Supreme Court. We've had a couple of instances here in California where you have a difference of opinion from federal district courts, all within the Ninth Circuit here, and we've been through the ringer with Duncan. which is now at the Ninth Circuit as well. But here we have another case where they're finding bans on magazines unconstitutional. Can you give us a breakdown of this one and maybe its path now that it's already behind Duncan?
Well, this is a Oregon State Court case, and I'm not quite sure why the plaintiffs decided to file this case in state court. Maybe they knew this judge was kind of inclined to go their way, but they won at the trial court level, and then it went up on appeal, and the Oregon Court of Appeals heard oral arguments in October. So it's fully briefed. They heard the arguments. It's under submission, which means we're waiting for a ruling, and that's about where that stands. I'm not sure how they're going to, or whether they're even going to apply Bruin as opposed to some state law issue. But it was a positive ruling at the state court, at the trial court level. And so we'll have to see what the Court of Appeals does. But again, all these cases, even if it's a state court case, if we win or lose, if we lose, the government seizes on it and says it's persuasive authority that we should be bound by. A state court can't bind a federal court, especially on a constitutional interpretation question. So it will have mandatory authority in the state of Oregon, but not with the rest of the Ninth Circuit, no matter how it comes out. But it's a magazine case, and whether a magazine is an arm is still a question that a lot of these courts are wrestling with, and whether or not they're entitled to any kind of Second Amendment protection, or you are, for owning one, choosing to own one.
Well, certainly there's still a lot to fight for, but looking back on 2024, it also seems like there's a lot to be happy about, especially a couple of these decisions that the Supreme Court has handed out, and a lot still to look forward to. Guys, I feel like we can do more. If you want us to focus a little bit more on some of these cases external to California, leave a comment below. Let us know how you feel, that you want to be informed on these as well. Like Chuck said, we do watch these cases, and in instances where we can help with amicus briefs that can eventually come back to help us with a good decision, we do end up filing those. So hit us up in the comment section if you want to see more videos on some of these cases external. Chuck, I guess as a final thought, looking into 2025 litigation, a lot of these seemingly have a path to, at the very least, appeal to the Supreme Court. What's the outlook for you in 2025?
Well, hopefully Snopes will be taken and set a lot of things straight. Let me take a second, though, and give a hat tip to the Second Amendment Law Center. Maybe you guys can put a link in the comments, the 2alc.org, because that is a national game. They're playing all across the country, along with CRPA. CRPA and 2ALC work together on a lot of these cases that are outside of California. So folks should have a look there and see all the good work that group is doing. And of course, CRPA is doing similar work because of the issues that will impact California, no matter what other state they may be decided in. But ultimately, this is a waiting game for the Supreme Court to take another case and once again shut down some of the intellectual bending over backward to try and twist Bruin, so that the courts that are biased and inclined to uphold gun control get away with it because they misinterpret or misconstrue or misportray what the Bruin court really said, the Bruin decision by the United States Supreme Court really said. So that's where things are headed. There's a lot of cases that are sort of queuing up in the flight path, and we'll see which one. I think we're going to see one or more ends the Supreme Court in 2025.
And we'll certainly be following along to do that. Chuck, I know that you're a busy guy. As always, I appreciate you coming on and sharing this wisdom with us.
My pleasure, guys. Hey, Merry Christmas, Happy New Year. We'll see you on the other side.
Absolutely, we will, and we will be there fighting as always. And guys, if you like content like this, you want to be informed on these kinds of cases, if you want to directly contribute to the Second Amendment fight here in California, please, one more time, be sure to smash that like button, comment on the video, and share with as many people as you can. We want everybody to be as informed as possible. Thanks, guys, and we'll see you on the next one.